Welcome to FOXSOUL's Black Report with our continued coverage of the murder trial of Derek Chauvin. My name is Romeo.
Hey there, I'm Brooke.
I'm Demi.
And I'm Melissa.
On today's report, we discuss the role of faith, policy, and activism as it relates to the murder of George Floyd with Reverend K.W. Toulis and Dr. Mark Whitlock.
Also, California State Assemblymember Chris Holden is here live on the show to talk about how George Floyd's death is impacting lawmaking in the Golden State.
Our legal expert, civil rights attorney Sue Ann Robinson, is back to help us recap today's proceedings, and we have your Justice for George Floyd trending headlines.
Yes, we have all that and so much more. If you're ready, it's our voice and our truth. Let's get it.
To me, this reeks of conflict of interest.
Do we know if he actually waved a gun? We only hear one side of the story.
This just really did make me feel good that the justice system did what they needed to do.
We're going to keep following this story, and we will have the latest for you. So, Miss, unfortunately, we have to begin with sad news. U.S. Congressman Alcee Hastings has died. His chief of staff confirmed the news to CNN. The Democratic rep was 84 years old. Back in January, Hastings announced he was being treated for pancreatic cancer. At the time, he did let voters know he planned to remain in Congress during the treatment and calling it a battle worth fighting. Hastings first began serving in the U.S. House of Representatives back in 1993. One of his last acts involved his support of the George Floyd Justice in Policing Act. Take a look at this.
Now, I imagine many of my friends on the other side of the aisle, I heard some of it yesterday, are going to say the George Floyd Justice in Policing bill doesn't do this and it could do that. Simply because this bill may not be the reflection of the perfect vision of all members of this body does not mean it is therefore unworthy of the support of members of this body. Currently in this place, the George Floyd Justice in Policing Act is worthy of every member's support.
Soulmates, here's what happened today during the trial of former Minneapolis police officer Derek Chauvin, who's been charged in the death of George Floyd. 4 witnesses testified in court today. Minneapolis Police Lt. Johnny Mercil testified earlier today about the use of neck restraints by police officers at the department. Los Angeles Police Department Sergeant Jody Steiger, a use of force expert, testified today that the force used by a former Minneapolis police officer, Derek Chauvin, on George Floyd was excessive. Minneapolis police officer Nicole McKenzie, a medical response coordinator at the department, testified that it would be incomplete to say that if someone can talk, that means that they can breathe. Minneapolis Police Sergeant Kerr Yang, the crisis intervention training coordinator for the department's training unit, testified about the importance of recognizing when someone is in crisis and de-escalating the situation. Midday today, in a news conference held outside the Minneapolis courthouse where the Derek Chauvin trial is taking place, George Floyd family attorney Ben Crump introduced the Floyd family and Reverend Al Sharpton, who got together to pray. Sharpton came to Minneapolis to visit the family after last week's emotional witness testimony in the death of Floyd.
Joining us now to break down today's testimony is our legal expert, Sue Ann Robinson. Welcome back, Sue Ann.
How are you?
Oh,
can we hear you?
Yes,
Oh,
we can hear.
Are you okay? I can hear.
Here I am.
Hey,
Sue Ann.
One quick button press, and now you're back. So, always love to have you on the show. Let's hop right into it. A lot happened today for those who are watching the trial. I want to ask you, so law enforcement was center stage at today's proceeding. Let's start with Minneapolis Police Lieutenant Johnny Mercil. Mercil, he confirmed to prosecutors that restraint is a form of force and that both applying force or applying restraint needs to be proportional. He was shown Chauvin on Floyd's neck, and here's what he had to say.
In addition to the classroom training, you actually teach officers, show them physically how to do these sort of neck restraints?
Yes, sir.
At this time, I'd like to republish Exhibit 17. Sir, is this an MPD trained neck restraint?
No, sir.
Has it ever been?
Not to my neck restraint? No, sir.
Is this a MPD authorized restraint technique?
Knee on the neck would be something that does happen in use of force that isn't unauthorized.
And under what circumstances would that be authorized? How long can you do that?
I don't know if there's a time frame. It would depend on the circumstance of the time.
Which would include what?
The type of resistance you're getting from the subject that you're putting the knee on.
And so if there was, say for example, the subject was under control and handcuffed, would this be authorized?
I would say no.
If you could take that down, please.
Sue-Ann, so I'm really happy to have you here because this was really important testimony today. So, you know, there's a lot of talk about the knee on the neck versus the shoulder. Do you think his testimony was harmful or helpful to the district attorney team?
I think that his testimony was helpful, especially with respect to his conversation about proportionality, because the argument that the state can make in closing is that the force that was applied was not proportional to what was occurring, which was George Floyd was handcuffed on the ground and in compliance. And so you meet deadly force with deadly force. You don't meet compliance with deadly force. And I think the state having that witness testify is going to allow them to make that argument in closing.
So in Minneapolis, Police Officer Nicole McKenzie testified on the topic of CPR and that it would be incomplete to say that if someone can talk, that means they can breathe. Take a look.
Are officers trained to do if they are unable to find a pulse?
If you don't have a pulse on a person, you'll immediately start CPR.
Now, I want to go back to the concept of checking for breathing. You indicated that you can look for the chest rising and falling. Is that right?
Mm-hmm. Yes. Yes.
All right. Do you train officers that, as part of your training, do you train officers that if a person can talk, means that they can breathe?
No, sir.
Okay. Why not?
Well, that would be incomplete to say, because there is a possibility that somebody could be in respiratory distress and still being able to verbalize it. Just because they're speaking doesn't mean they're breathing adequately.
All right. And getting back to circulation, you indicated that if the officer cannot find a pulse, they're to start CPR. Is that correct? And describe what is done to start CPR.
So to start CPR, if you're going to be starting that, if you haven't already contacted EMS to get them en route, you would do that immediately. Then it's a matter of just interlocking your fingers, and you go center of the chest, and then you push down about 1/3 of the depth on that person at the rate of about 100 beats per minute.
And is this something, that, again, getting back to the MPD policy, that the officer is trained that they're required to do while they're waiting for the ambulance?
Yes.
And when is the officer supposed to stop CPR?
When you've been relieved by somebody with a higher level of training than you, or if there was some obvious signs of death, or if you've been doing it for a while, if you're absolutely just physically exhausted from doing CPR.
If you could display page 27 of the exhibit. Right. And officers are specifically trained on this, is that right?
Correct.
It can be when the subject becomes responsive or wakes up.
Right.
Or someone else takes over. Or as you stated, it's not safe or you physically can't do it anymore. Is that
correct?
Right?
Yes.
Okay. And is this consistent then with the training that you provide every year to each and every law enforcement officer who is recorded as having taken this training during in-service?
Yes.
Definitely very powerful. Sue-Ann, at what point do you think the district attorney's team is trying to make to the jury?
Well, we'll discuss it, but the charges all have to do with his state of mind. And there's a defense argument that because George Floyd was speaking, Chauvin was unaware that he was killing him. And so the fact that he's been trained that just because someone is speaking doesn't mean they're not having respiratory failure is the prosecution's direct shot at that argument. Oh, he's talking, so that's why you didn't realize that he was in respiratory distress. Well, another officer is saying that we're trained just because someone is talking doesn't mean they're in respiratory distress. Honestly, it's common sense to all of us, but something that has to be brought into evidence. So again, the prosecution can make those arguments directly to the jury in closing.
Sue Ann, Los Angeles Police Department Sergeant Jody Steiger testified he conducted 2,500 use of force reviews and has found the use of force was reasonable in some and not in others. Are we going to an SOT? I didn't get that. Okay. Okay. Actually, you know what I wanted to ask you? I wanted to ask you about a case that he referenced. He referenced Graham versus Connor. Can you tell us about that case and why it applies here?
Which witness?
Jody Steiger.
I think the issue with Jody Steiger's testimony is that, again, the state is trying to stack up the fact that Chauvin knew what he was doing because his state of mind is so critical. That particular case has to do with what we've been discussing, the theme, which is that it goes to the officer's state of mind at the time, that we're not supposed to Monday night quarterback what an officer's doing because we're not in their place at that moment, at that time, to make that snap decision. However, all use of force efforts are always reviewed. So an officer is not allowed to use whatever level of force they feel like. It's always going to be reviewed. And so while that case says it's to be viewed by the individual officer, their actions still have to be reasonable. And so that's why they brought up that case.
Police Sergeant Kerr Yang. He's a crisis intervention training coordinator with the Minneapolis Police Department. During the defense's cross-examination, they're still trying to push this idea that bystanders were angry and aggressive, which affected Chauvin's attention. Essentially, they're trying to push that turned his attention away from what he was doing to George Floyd. There has been a lot of back and forth about this. They've been pushing this hard. Do you think the jury is buying this?
No, and I think the defense is really insulting the jury by keeping on top of this narrative that Chauvin was in the middle of some Mogadishu, like some big fight, and that's why he had to maintain that status for 9 minutes and 29 seconds. I think it's insulting to the jury. I don't think the jury is going to take it well. The defense attorney even took the step to show the picture of the crowd and circle our MMA witness and say, isn't it in this picture, doesn't it look like someone's holding him back? Like, come on. The jury understands the circumstances, understands what's going on. What is on trial is what Chauvin did. So I think the defense should just stick to that and stop trying to paint a group of people that are actually trying to assist the officer by saying, hey, you're killing him, you're hurting him, and trying to distract him from doing that. Stop trying to paint them as some dangerous mob that's causing you to kill someone. I think the insult to the jury is trying to say that this mob is the reason why this scenario ended in the taking of his life. I think that's the insult to the jury.
Sue Ann, I want to follow up there because I want to go back to Johnny Mercil. We were talking about him at the beginning of the interview, and they also touched on that with him, a big back and forth, right? So basically the defense in cross-examination was able to get him to say that threats, like if they were saying, and I don't want to use the foul language, but they were, saying, we've talked about it before, some of the foul language that they're saying bystanders were using. I think they also said that, hey, if the bystanders are saying, I'll kill you, could that be distracting? And so he says yes. And then in redirect, they come back and say, okay, well, in that same frame of mind, if they also say you're killing him, if you're able to understand one and react to that, shouldn't you be able to understand two? Who do you think won that?
I honestly thought that the redirects were great for us. I was very keen that Judge Cahill even allowed it, but it shows you the nature of trial. They are, staying on top of things minute by minute and responding to exactly what's happening. I think the prosecution won that because the point was, yes, people are yelling things. People might be yelling foul language, but he ended with, they were yelling, you are killing him. Yes. Correct. And wouldn't that stop you? Wouldn't that make you take a different action as well? Yeah. And I think, so that's why I think that sparring contest definitely went to the prosecution.
Sue Ann, I absolutely agree. And Brooke, I'm so glad you touched on that because it was a good moment And I feel
strong,
like, too,
right?
that the prosecution definitely took that. But, Sue, and I want to ask you one more question. So, Cahill says that the defense wants to bring back Nicole McKenzie during the defense's case next week. So it also kind of let us know where we are in the case, that the defense is going to start with their witnesses. So why do you think out of all the witnesses that were chosen, why her?
Well, they might be bringing her back as a rebuttal witness. I didn't see anything particularly alarming about the way she testified for the prosecution, but they might want to bring up things with respect to his training and training that he's attended. Because I remember earlier in testimony when the defense was cross-examining, they were saying, well, there was certain trainings and certain information that the officers were given, but was Chauvin specifically given this training or information, or did he actually sign in for this training or information? And so they might be recalling her for that, to ask, okay, you're saying you trained on this, you trained on neck restraints, you trained on what not to do. Was Chauvin actually present for these things? And if he wasn't, or if no one can testify that he directly was given that information or that training, that could be a small point for the defense. I honestly think that, as I've said before, he's better off just saying he blacked out and didn't know what he was doing than insulting the jury with these small, tiny arguments that are going to fall flat, in my opinion.
A couple things down to me, Sue, and I want to ask you real quick. Last night, there was someone reporting saying at this point they feel like Derek Chauvin should just go for a plea deal because there's no way he can win. That's what some people are saying, obviously. But one word that stood out to me today was obligation, right? They were sitting up there, they were saying that police officers have the obligation to go ahead and assist someone that's in need, and that's something that didn't happen, not only from Derek Chauvin, but from the rest of the officers as well. So I'm sure, that was a huge point. That's going to carry over when the other cases come to trial as well, right? Wouldn't you agree?
Yeah, that goes to his state of mind, because the charges in this case, the only difference in the charges is his mental state. And if you're saying that you didn't mean to do what you did, you didn't mean to kill him, then you should have immediately, once you realized that he was in distress, that he didn't have a pulse, you should have snapped into your first responder mode and been trying to help. So the fact that he didn't goes to his state of mind, that he did in fact know what he was doing, and he was trying to end George Floyd's life because he did nothing to help him, even though he had an obligation to do so.
Yeah, very well said.
Sue Ann, as always, we're so lucky to have you.
Yeah. I mean, always so lucky. And we're going to check in with you tomorrow as well. Thank you for taking some time out of your busy day.
We appreciate it.